Hello and welcome to the very first edition of Let's Talk Human Rights, the new video and podcast series by the Maastricht Centre for Human Rights. In this series, we will be speaking to a number of different human rights experts about their research, their area of expertise, and their experience as human rights researchers. We have a particular focus on early career researchers, so those who are only just starting out on their career in human rights research. My name is Sally Thin. I am a PhD candidate in international law, and I will be your host for today. Here with me are the lovely Sarah McGibbon and Stephen van de Putte. Would you like to introduce yourselves, Sarah?
Sure. So I'm Sarah. I am a PhD candidate here at Maastricht University. I am in my final year of my PhD now, so I've been here for 4 years. My research focuses on the responsibility and capacity of what I call effective non-state territorial entities.
I'm sure we'll get into exactly what an effective non-state territorial entity is in more detail later on. Stephen?
Yeah, hi, I'm Stephen. I'm also a PhD candidate here at Maastricht University. I'm an external PhD candidate, so I'm combining my research here with my function at the Netherlands Defense Academy. And my research looks at accountability and reparations for human rights violations during UN peace operations.
Thanks. Now, doing a PhD myself, I know how frustrating it is when somebody asks you to summarize what it is that you do for your research. But if you could you please give a brief overview in a few sentences of what your research is? Sarah, if you'd like to start again.
Oh, I was hoping Stephen would have a chance. So effectively, what my research is all about is what I would say entities that look and feel like states, but aren't states, as we understand that term in international law, and understanding how the international legal framework treats them, what capacity we allocate them, and how we assign them responsibility, if we assign them responsibility in international law.
And are you looking at any particular examples?
Yes, so I have 4 particular examples that I look at. I look at ISIS in the Middle East, in particular in Syria, Taiwan, Crimea, and Somaliland. So quite a geographically diverse set of examples.
Quite a mix. And Stephen?
Yeah, well, I look mainly at what happens whenever human rights violations are committed during UN peace operations, and then mainly if individuals would have a claim against the organization, and if they would, how that claim would need to be redressed. So, the main emphasis of my research would be on the part of what happens after the violation takes place. So, what would an organization, what claim would an individual have against the organization and be able to claim compensation or redress for the violation that was committed against them?
So I think 2 really interesting topics, but also what I think is also very interesting is the overlap between both of your research topics. Before we get into that, I just wanted to ask you quickly about how you got into human rights research. So what was it that made you interested in research in human rights, but also particularly in your topic? So how did you end up doing what you're doing just now? Stephen, would you like to start to switch
it up a bit? Yeah, well, originally I studied philosophy, politics, and economics, which was quite a broad degree. But what really interested me there was like kind of the more applied ethics. And within international law, that led me to kind of drift towards human rights, as I saw it as like, well, ideally at the time being idealistic and just having graduated from university as like affirmation of human dignity and sort of applied ethics within the world. And that really piqued my interest with that. And that led me to apply to do a master's in human rights law in Belfast. And Belfast has quite a unique history with human rights as well, especially during what took place there during the Troubles. And that actually led me more to also become interested in human rights during conflicts, especially in situations of armed conflict or, well, below the threshold of armed conflict, but still a lot very violent situations. And that's, eventually also led to my master dissertation, which focused on the Srebrenica cases, which were very topical at the time.
Yeah.
Sarah?
I'm from South Africa, and we obviously have a very dark and dirty history when it comes to human rights with apartheid. And in my final year of high school, we had to do a history project on something, and I chose to do the role of music in ending apartheid. And in researching this and kind of getting to know a little bit more about the sort of daily lives of people living under the apartheid regime, I became very interested in human rights, and the young idealist, I was like, wow.
I think we're all still idealists on some level.
I don't think it changes, does it? I thought, wow, you know what, I finally know what I'm going to do. I'm going to change the world. Had no idea what I was going to do in terms of like how that was going to happen, but I figured, you know what, human rights law sounds like a good place to start. Went off to university to study law, knew nothing about law, what it entailed, but luckily for me it worked out rather well. When I was finishing my undergrad, I focused my research on torture as a counterterrorism technique, and I then went into practice for a while. I also did my master's overseas and studied international law and international human rights, where I focused a little bit more on the international criminal law aspects of it. I then went back to practice in South Africa again. In my practice, rather than academic research, I've had the privilege of working for the Constitutional Court of South Africa. We did a lot of casework there on Bill of Rights litigation, which was absolutely fantastic and gave me a very practical insight into human rights and how that looks on the ground for implementation in litigation. But research has kind of always drawn my interest, and I kept coming back to this idea of there are issues that I want to look into, there are questions I want to ask, and that practice was not allowing me to do that. So when it came to the PhD, I knew I needed to come back and do the PhD at some point, and I then chose to focus on the non-state entities. My research is perhaps a little more general than your research, Stephen, but it sits at a level that asks about this responsibility and capacity issue, because it's something that affects the implementation of human rights. If we've got these geopolitical realities of these non-state entities that are very, very real in the lives of people every day, we have to know how to deal with them, how to enforce human rights, implement human rights, and ensure that they're protected. So that's why I went for a more general approach, but something that still allows me to impact human rights, which is very close to my heart.
Let me ask you there, because I think both of you in different ways are focusing here on non-state actors. And I think maybe some people who are listening or watching from home today won't necessarily know why that makes these questions much more difficult. So in brief, a non-state actor is exactly what it sounds like. So an actor in international law that is not a state. So that can cover everything from individuals to international organizations like the UN, to entities like you were talking about. Could you maybe explain why, when an actor isn't a state, that makes it particularly difficult to talk about human rights responsibility or human rights accountability in international law? Sarah?
Sure. So as you mentioned, I mean, the primary actors in international law are states. Another big one is international organizations, as you focus on. But ultimately, all responsibility in international law is they try to track it through states somehow. We work with customary international law principles of state responsibility, and there are all sorts of rules for assigning responsibility. We call it attribution, determining who's responsible for conduct and how we hold them responsible for that conduct. And if it's only states that are ever held responsible, but we have a large number of non-state actors in the international system or in the world, we have a huge gap where human rights it may not be effectively protected. They're not always the the people who are violating the human rights. In fact, sometimes they are doing a better job of protecting human rights than the states themselves. But there is a gap in human rights there when you have a massive actor that's not actually dealt with in the attribution framework.
Yeah. So essentially we, in international law, we focus a lot, perhaps you might say too much, on what states do and don't do, and sometimes within that perspective, non-state actors can slip through the net. When we're talking about responsibility and accountability for human rights, especially by non-state actors, what are the different steps that we need to kind of get through, or that we need to establish? Stephen?
Yeah, well, I think one of the first challenges would be establishing that a non-state actor has an actual obligation. So there are a couple of sources of obligations within international law. They could be treaty-based, which are kind of agreements conducted between states. But you also have customary law, international law, and you can now see that a lot of people have started to argue that certain human rights now form part of customary international law. And that is argued by basis of state practice, so what states actually do, and what legal scholars call opinio juris, or the conviction that what they do is also the result of a legal obligation. So that would be kind of the first step, because without that you can't really discuss a violation. Then if you have established that there is an actual obligation, then the second step would be what Sarah already mentioned, would be to attribute that to the party in question. So there are some certain rules within international law that deal with the attribution. What you can see is that they're quite well developed when it comes to states, but that it's a lot more difficult to argue effectively when you're dealing with non-state actors. And you see that both on the cases of international organizations, where there's a lot more discussion about who's responsible, either the state that's a member of the international organization or the international organization itself. And I don't really even want to get into the hornet's nest that Sarah's dealing with when we're talking about attribution. If you've established those two, then you can kind of speak about a wrongful act, which in general international law terms would lead also to an obligation to compensate or provide redress for that act. There are, however, some exceptions to that rule, which are summed up with the all old lawyer saying of "it depends." But some entities within international law have far-reaching immunities, and I think my research, a big part of that is dealing with the immunity of the UN, because if you see now, for example, in both the Srebrenica cases, there was a big case in Haiti which dealt with cholera, which was allegedly spread by Nepali peacekeepers that the UN sent there. But in all those cases, the courts pretty much say, well, the UN is immune, so you can't bring your case here, which kind of leaves the victim without an avenue or a forum where they can bring their case to. Lastly, which is also a bit more of a contentious issue as well, is that you would have to argue, if you're talking about individuals, that the individual would have a claim. Within international law, what you see is that states are the primary actor, but that's occasionally also the case when it comes to redress, which would mean that the state would have to argue on behalf of its citizens to claim that a violation has taken place, instead of that citizens can do so directly against the entity that has offended their rights. So those are kind of, I would say, the four major steps you would have to establish for talking about accountability and redress for human rights violations.
So let's take it back to the first one then. I think there's a lot in there to unpick, and I hope we'll have time to go through at least most of it today. But for the actual obligations, so the obligations that we're talking about, whether or not non-state actors have violated these human rights obligations, what kinds of obligations and what kinds of violations are you both talking about in your research? I know, Sarah, yours is quite general, quite like abstract level, but you're looking in particular at peacekeeping operations. So what kinds of, what kinds of conduct are you talking about within peacekeeping operations, and what human rights do you think are being violated there, or have been violated? Have been violated.
Yeah. What you have is some very big incidents. Like there was, it was the Somali affair where Canadian peacekeepers were accused of torture within Somalia. And that was, that led to major cases. But then, for example, because those were criminal cases within Canada, it kind of left the victims without an opportunity to present a claim or to gain any form of redress, because Canada wouldn't allow a litigation guardian, and they weren't able to prosecute within Canada themselves. So I would say torture would be a main one. You also see that in some cases it has been argued that sexual abuse can amount to torture, so that would be a broader category within there. And lastly, I think a lot of it is also focusing on the right to life. What you see is that within international law, there's two frameworks which kind of deal with the use of deadly force. You have international humanitarian law, but international humanitarian law generally only applies within armed conflict. And what you see with peace operations is that they operate in a lot of areas where they do use deadly force, or there is still violence, but they fall below the threshold of an armed conflict. In those cases, the use of deadly force could amount to a violation of the right to life within human rights law. So I would say those are the two main ones I'm currently looking at.
As violations by the UN itself.
Yeah.
And do you look at particular human rights, Sarah, or are you looking more generally at the capacity to respect human rights?
I'm looking more generally, although there are examples that come up in sort of each territorial study, and that can differ from place to place. And one of my territories is Somaliland, Somalia, so there are some rights that you've perhaps seen in your research that come up. For example, ISIS in the Middle East, there's some, of course, some human rights issues there. Although I think it's a little bit more general in the sense, for example, of looking at things like the right to citizenship or nationality and statelessness. That's something that comes up in my research, because if you've got residents of these territories where they've got a completely different legal system to the, let's say, recognized state, for lack of a better term, although I don't like that term, but recognized state, would their citizenship, their nationality be recognized by other states? Are they stateless? Are they not stateless? These are the kinds of questions that do come up in my research.
Could you give an example of one of the places where there's perhaps a recognized state and then an unrecognized territorial entity?
In my studies? Yeah, so so I think China and Taiwan are a very good example, quite a topical example at the moment. So I work with the 4 different entities, for me, represent a spectrum of these non-state entities. I don't work with international organizations like you do. I've excluded those from my research, from something that looks the least like a state to something that looks the most like a state. But Taiwan and China are a very good example because Taiwan has its own constitution, its own courts, its own military. It looks and feels very much like a state like the Netherlands, where we sit here today, for example. But it is legally part of China, and there are repercussions for states that would say they recognize Taiwan as an independent state from China. And interestingly, there are some relations developing there. For example, between Somaliland and Taiwan, there has recently been some exchange of I wouldn't say diplomats, because they're calling it unofficial. It's not official recognition, but they have set up offices in Taiwan and in Somaliland that looks a little bit like diplomats. So there are these sorts of things happening on the side, but technically Taiwan would be considered an unrecognized state within the recognized state of China.
Good example. So we've talked a little bit then about the obligation side, and then I think, if I remember correctly, the next step that you said was attribution. And I know that both of you deal with attribution as quite a big part of your research in different ways. Perhaps for those at home that haven't studied international law before, essentially we need to talk about attribution because in international law, often the actors that we're talking about aren't real in the sense that they aren't an individual. So you can't say that Germany has done something, it is perhaps Germany's foreign minister or president or somebody in the German armed forces. So when individuals carry out conduct, we need to have rules to say who that conduct is attributed to. So who in law has done that conduct, so to speak. And we have rules for doing that with states, so for attributing conduct to states. But then, as I understand, at least from your research, the rules for attributing conduct to non-states are slightly more complex. Could you perhaps go into a bit more detail as to how you deal with attribution in your work? Sure. Stephen?
The issue you have with the UN is that there's technically the possibility of attributing it to two actors. Because the UN doesn't have its own military forces, as soon as they conduct peace operations, they borrow military personnel from member states and they actually execute the peace operation. And what you then get is quite often a debate if a violation takes place, if that can be attributed to A, the state, or B, the international organization. And I think a good example of where you've seen that is what I already briefly mentioned in the introduction is the Srebrenica case. The courts there went into quite a detailed examination if the Dutch state would be responsible or if the UN would be responsible. What the court said there is that in general, it doesn't see any reason to not believe that double attribution is a possibility. So it's not a possibility. So it didn't really exclude that as an option, but it said that, for example, usually it would be the case that whenever peace operations are conducted, military personnel then acts as an agent of the organization and that the organization was responsible. But in the specific case of the Srebrenica cases, that because the Dutch government was so involved with the redeployment of the forces, that it said that the Dutch state in this specific case was also responsible for the fall of Srebrenica.
Mm-hmm. So then I suppose there are two questions there. There's the question of whether the breach itself, so the act of violating the human rights, is attributable to potentially two different actors. But then I suppose, for me anyway, the question also arises, so who is actually responsible for respecting and fulfilling human rights within a particular territory? Is that something that you deal with, Sarah?
It is and it isn't. So my research has focused on this notion of attribution more generally and understanding the flaws in it. It's a little less developed, the framework, in relation to my entities. And what we found, or what I found, is that it always comes back to states. They always try to, when I say they, states, courts, they always try to bring it back to states, whether that be through non-state actors acting on behalf of the state or them being effectively controlled by the state. This is a term that has come up through the jurisprudence. So at the end of the day, they always wanted to be a state. And I think when we talk about human rights, there is a little bit more room for the understanding that non-state actors may have some human rights obligations, and there are arguments that are made that they may have human rights responsibilities. But I think that primarily the main argument is still that that states have some kind of obligation to ensure that non-state actors are protecting human rights. My research is then trying to shift that discourse a little bit and say that we can focus a little bit more on non-state actors as non-state actors, and work more with them as a very real player in the system. Do you find that that's the same for you? That it's if you think, I know you work mostly with organizations, but
yeah,
would you say that you agree that it's still state-based?
I think that's also just, I think that's the same within my research, but I think that's also just a result of necessity, as in because the UN's immunity is so kind of well established, people start looking for alternative ways to still get a form of redress. And I think that has influenced why people have started to try to hold states accountable instead of the international organization. I don't think that's legally correct per se, but I think that is currently kind of the path of least resistance.
I think when you have a system that is entirely built around states, then it becomes the easiest way to do that, doesn't it? So
we are coming to the end of our time, but what I would like to have from you each in a couple of sentences, if you can, why do you think your research matters? So why do you think your research is relevant in the real world? Because often as researchers, academics, we get that criticism that, you know, you kind of live in an ivory tower, you aren't so connected to the real world. So in a couple of sentences, why do you think your research matters for the real world? Sarah?
So like I mentioned, it seems quite general and theoretical, but at the end of the day, it is very relevant in the lives of people who live in non-state territorial entities, because it affects questions like marriage, divorce, adoption, nationality. Will these kinds of acts be recognized in other states, and particularly, for example, with the movement of people around the planet at the moment, both refugee and non-refugee, these issues become very real. So I think that is the shortest version I can give you of the relevance.
Stephen?
Yeah, well, I think if the UN takes its role seriously as an organization built upon human rights, it should also, in a way, offer redress and compensation for human rights violations that are committed on its watch. I think that's both like an operational incentive. We live in a world that's emphasizing accountability a lot more, especially within international law. You have the ICC, and a lot of that institutions like that pop up, that the hybrid tribunals that deal with violations and say that impunity is no longer acceptable. And then on the other hand, I also think that it's just also to offer some redress for the victims there. At the moment, there is just a massive accountability gap, and I think that's still something that needs to be addressed at the moment.
Well, two very interesting research projects. I'm looking forward to reading them when they're finished. Now I have one last quick question for you to be as serious or as silly as you would like. If you could add one new human right to human rights law, what would it be? Sarah?
It would be the right to free access to menstrual products to people who menstruate.
Stephen?
I think there might be a discussion had with technical developments at the moment about a right to a basic income.
Two very interesting new human rights for the human rights lexicon. I think also both probably very beneficial to human rights law to have those conversations. Thank you very much, Stephen. Thank you very much, Sarah. Thank you very much to everyone at home who listened or watched this. If people want to find out more about your research, how can they find you, Stephen?
I am on Twitter, not very active yet, but it is developing.
I am not on Twitter, but people are welcome to check out my university webpage and contact me directly through the details there, or my LinkedIn profile.
Thank you. So once again, that's Stephen van de Putte, Sarah McGibbon, thank you very much. You can, of course, always find out more about the researchers at the Maastricht Centre for Human Rights at Maastricht University .nl /MCFHR. That's maastrichtuniversity.nl /MCFHR, or on Twitter at MC_human rights. Thank you, Sarah. Thank you, Stephen. Thank you, viewers and listeners. And we hope to see you back here again next time.